Hello everyone, welcome to BYJU'S exam prep. I'm Nivedita Raje and this is what we are going to study today, the top 20 legal judgments, and we're discussing the most important judgments of a particular month, the month being August, September and respectively. So these are going to be conducted in parts. How are you all? Good evening, good evening. Hello, how are you all? Good evening, guys. So what's happening? Good evening, everyone. Good evening. So, top 20 judgments. It's not just about reading the judgments per se. जब हम judgments की बात करते हैं, मैं पहले भी बता चुकी हूँ, तो हम सिर्फ वो नहीं देखते हैं जो सुप्रीम कोर्ट ने बोला है, क्योंकि सुप्रीम कोर्ट बहुत सारी चीजों को लेकर बहुत सारी बातें बोलता है. लेकिन एक लॉ जो कंसर्न होता है, the law that is involved, the area that they are delivering the judgment in, so that area is diverse. It has multiple facets of laws which are relevant to your syllabus. तो उस एक जजमेंट के थ्रू देयर आर सो मेनी concepts that we are able to learn, and that is what makes these sessions important. आप जब एक जजमेंट पढ़ रहे हैं तो वो जजमेंट आपसे एग्जाम में नहीं पूछा जाएगा, लेकिन उस जजमेंट से रिलेटेड जो लॉ है, जिसपे रूलिंग आई है, जिसको डिस्कस किया गया है या जिसे नहीं भी डिस्कस किया है, लेकिन वो एक पर्टिकुलर कॉन्सेप्ट था जो उस जजमेंट में था, वो इंपॉर्टेंट हो जाता है और उससे रिलेटेड पूरा का पूरा पैसेज निकल कर आ सकता है. राइट. सो दिस इज व्हाट अ होलसम प्रिपरेशन इज. अब आप उस जजमेंट को पढ़ते हैं, उससे रिलेटेड जो लॉ है आप उसे पढ़ते हैं, और इस तरह से आपकी एक बहुत ही होल हार्टेड और होलसम प्रिपरेशन हो जाती है. I'm good. Thank you so much for asking. So part 2, and these are the list of the judgment that we are going to discuss today. They're all 22 judgments. सारे September, August के judgments हैं, so very latest. They just happened, and that is what makes them important, right? So they contain everything. It's not just a far-fetched law that they might contain. It's the civil, criminal, everything is involved. Some concepts that students generally overlook because they think यार इसमें से क्यों आएगा, but वो आ जाता है. क्यों आ जाता है? Because Supreme Court ने उस पे कहीं ना कहीं कुछ ना कुछ कह दिया था. Right. So we are going to study Dilip Hariramani versus Bank of Baroda. Then we shall study IOCL, Indian Oil Corporation Limited versus Sudera Realty Private Limited, XYZ versus State of Madhya Pradesh, Ajola Devi and another versus State of Jharkhand. Right. So let us start with the first judgment. Now the first judgment is Dilip Hariramani versus Bank of Baroda, and in this case the Supreme Court said that vicarious liability for check dishonor merely because a partner was a partner in a firm or a guarantor of a loan will not arise. इसका मतलब है कि just because एक आदमी उस फर्म का पार्टनर था या फिर जिस लोन के लिए चेक बाउंस हुआ है या डिसऑनर हुआ है, उस लोन का वो गारंटर था, बस इस रीजन से उसकी लाइबिलिटी नहीं होगी. कहाँ नहीं होगी? सेक्शन 141 के एनआई एक्ट, नेगोशिएबल इंस्ट्रूमेंट्स एक्ट में. अब क्या है इसमें? देयर आर मेनी concepts. First concept is vicarious liability. What exactly is vicarious liability? Now mind you, this is a very important and sort of a little complicated topic. Then we have section 141 of NI Act. This is one of the few sections that creates a criminal liability in a civil offense. Okay, when to start latest judgments for 24. Yug, actually this forms part of current affairs only. ये हो जाते हैं लेटेस्ट जजमेंट्स. आप साल भर के पढ़ सकते हैं, मतलब somewhere the entire year that you're preparing for, everything keeps coming, so you need to be updated. Pranam ji, pranam. So section 141 of the NI Act and guarantor of a loan. So there are three concepts. We are not concerned with the judgments per se, but we are concerned with these three concepts. Okay, vicarious liability, guarantor, and section 141 of the NI Act. Up. समझ लेते हैं इसको. Let's understand what the Supreme Court said. So the Supreme Court said that the guarantor's liability under the Indian Contract Act is a civil liability. The appellant may have a civil liability, but may also be liable under the recovery of debts, etc. But he is not liable under the NI Act. Is this needed for 24? The concepts that I'm teaching, मैंने अभी क्या बताया? I just told you that the judgment per se is not important. The concepts within are important, and these concepts are static, and these are important even for 2030. Okay, so don't go inside what is the judgment, because you're not really reading the current affairs part. You're also studying the static portion. ठीक है, जजमेंट का एक करंट से तो रेलेवेंस होता ही है, लेकिन सुप्रीम कोर्ट के जजमेंट जो होते हैं वो स्टैटिक इंफॉर्मेशन भी बहुत सारे देते हैं. उसमें बहुत सारा लॉ होता है, बहुत सारे कंसेप्ट्स होते हैं, सेक्शंस होते हैं, प्रोविजंस होते हैं, और उनकी क्या फिलॉसफी है, क्या उनका मीनिंग है, ये सब समझना पड़ता है. और ये तो हमेशा दे विल रिमेन रेलेवेंट till law remains relevant in CLAT. Are you getting my point? So yes, to answer your question, yes, it is important and it is needed for CLAT 2024 also. Okay? Got it? Now, let's start. What exactly is a guarantor? Let's assume a situation in which there's a person A and there's another person B. There's a third party C who is a money lender who lends money on a certain interest. Now, B needs a loan for his house. I'm trying to draw a house. Be patient with me. Okay. B needs loan for his house. But on his own, he cannot secure a loan because he does not have any other property. His assets are not that strong and he cannot keep anything as a collateral. ठीक है, अब इसका क्या मतलब है? फिर से समझ लेते हैं. लेट्स से कि एक पार्टी है, बी एक पार्टी है, और सी एक मनी लेंडर है जो पैसे को उधार पे देता है एक सर्टेन इंटरेस्ट के साथ. अब यहाँ पे बी को लोन की जरूरत है घर के लिए, राइट? और वो घर के लिए लोन तो लेना चाहता है, बट लोन सिक्योर करने के लिए उसके पास कुछ नहीं है. क्या मतलब होता है इसका? Whenever a person is giving money or lending money, he needs a certain security that in case the money is not returned, he can sell something and recover the money. कोई आपको पैसा यूं ही नहीं दे देता है, हर किसी को एक सिक्योरिटी चाहिए होती है, राइट? Whenever you move in a house, they don't just charge you rent, they also take a certain security so as to safeguard their house. In the event of the tenant destroying or doing some harm to the property, the landlord can repair the harm from the security amount, right? Similarly, in a loan also there's a certain security which is called collateral. Okay, अब यहाँ पे बी के पास देने के लिए कोई कोलेटरल नहीं है, इसलिए सी उसे लोन नहीं देगा. अब ऐसी सिचुएशन में बी क्या घर ही नहीं बना पाएगा? नहीं, बना सकता है वो. बी के पास एक और ऑप्शन है जो से इंडियन कॉन्ट्रैक्ट एक्ट 1872 से मिलता है, और उस ऑप्शन को कहते हैं गारंटी. अब यहाँ पे बी का दोस्त अगर एक बहुत अच्छा फ्रेंड है और वो सी के पास जाके कहता है कि सर आप बी को लोन दे दो, मैं गारंटी लेता हूं कि बी आपको वापस करेगा आपका बोरोड लेंड अमाउंट. ओके, okay, I really don't know how that is important, but if you are excited, I am happy for you. Okay, तो पहले पढ़ लेते हैं, है ना? अब यहाँ पे ए कहता है कि आप बी को लोन दे दीजिए, मैं गारंटी लेता हूं कि जितना पैसा बी ने आपसे लोन पे लिया है, बी आपको इंटरेस्ट के साथ लौटाएगा, और अगर बी नहीं लौटा पाता है तो मैं आपको वो पैसा इंटरेस्ट के साथ लौटाऊंगा. बेसिकली मैं गारंटी लेता हूं कि आपका लोन्ड अमाउंट आपके पास वापस आ जाए, चाहे वो मेरे थ्रू आए, चाहे वो बी के थ्रू आए. This is what is called I'm not getting. Okay, yes. So this is what we call a guarantee. I'll explain again in English. So we'll start from the beginning. There are three parties, A, B and C. C is a money lender and C lends money on a certain interest. Now the situation is B needs money or loan for his house, but he does not have anything to secure his loan, to keep something as a collateral, due to which he is not able to get any amount. Now A here steps in like an ideal friend and tells B that I guarantee you that the money that you are lending will be returned to you. In the event B is not able to return you the money, I shall return you the money. And this is what we call contracts of guarantee. Now this is a very usual and an accepted system in recovery of debts in India, and banks also go for the system. It is not like only the private money lenders or people who are involved in हाउस लेंडिंग, जैसे उसका उधार ले लिया, इससे उधार ले लिया, ये सब. Even nationalized or proper financial institutions go with these contracts. So these are called contracts of guarantee. Now, did you get it? Did you get it or not? Everybody. I need a yes or a no. Did you understand the contract of guarantee? Okay. Now, what is Section 141 of NI Act? Negotiable Instruments Act. Section 141 says that in case the check is dishonored or bounced, for example, let's say I need a payment from a person and he gave me an amount in form of a check. Now, when I deposit that check, the check will take 3 days to reflect in my account. जैसे आप कैश जमा करते हैं बैंक में तो कैश तुरंत रिफ्लेक्ट हो जाता है, लेकिन जब आप चेक जमा करते हैं तो चेक का अमाउंट रिफ्लेक्ट होने में 2 से 3 दिन लग जाते हैं. अब चेक का जो अमाउंट है, मतलब चेक पे जो अमाउंट लिखा हुआ है, बैंक उसे उस रेस्पेक्टिव अकाउंट से निकाल लेती है. मतलब चेक में जितना भी पैसा है उस चेक ओनर के अकाउंट से उतने पैसे को निकाल के आपके अकाउंट में डिपॉजिट कर दिया जाता है. दिस इज द सिस्टम. अब इसके लिए जरूरी है कि जहां से पैसा निकाला जा रहा है वहां पैसा हो, मतलब अकाउंट में पैसा हो. तो लेट्स से कि चेक जो था वो 10 लाख का था और वो एक सर्टेन अकाउंट होल्डर के नाम पे था. अब उस अकाउंट में सिर्फ 2 लाख रुपए हैं, तो 10 लाख कैसे निकालेगा बैंक? इस सिचुएशन में वो चेक बाउंस हो जाएगा. अब चेक बाउंस एक क्राइम है और इस एक्ट को सेक्शन 141 क्राइम डिक्लेयर करता है. क्यों है ये क्राइम? अब I must have explained to you the difference between civil and criminal. So civil is more like an individual liability where the society is not involved, there is no menace to the society, there's no impact on the society. So more like a grievance between parties is a civil offense, right, or a civil act. Now this being a civil act does not invite penalty. Got it? इससे पेनल्टी नहीं लगती. मतलब अगर आप कोई सिविल एक्ट करते हैं या किसी के राइट को वायलेट करते हैं, आप पे कोई सिविल लाइबिलिटी आती है, तो जनरल रेमेडी जो होती है वो कंपेंसेशन होता है. लेकिन यहाँ पे एनआई एक्ट एक एक्सेप्शन क्रिएट करता है. कैसा एक्सेप्शन? कि अगर आपने चेक दिया और वो चेक बाउंस हो गया और 3 महीने के अंदर अंदर आपने चेक बाउंस को रीपे नहीं किया, मतलब जितना पैसा आपको देना चाहिए था उतना आपने नहीं किया, तो आपको सजा मिलती है. सेक्शन 138 इस पे पेनल्टी लगाता है कि आपको चेक अमाउंट का 3 टाइम्स पैसा देना पड़ेगा. और सेक्शन 141 इसमें इम्प्रिजनमेंट भी ऐड कर देता है कि आपको इस 3 टाइम्स पेनल्टी के साथ जेल भी हो जाएगी. तो ये सिविल एक्ट जो है क्रिमिनल पेनल्टी को इनवाइट करता है और इसीलिए ये एक एक्सेप्शन है. गॉट इट? सेक्शन 141 का ये सिग्निफिकेंस है. अब वाइकेरियस लायबिलिटी समझ लेते हैं. इस केस को समझने के लिए हमें तीनों कंसेप्ट्स को समझना जरूरी है. वाइकेरियस लायबिलिटी क्या होती है? इमेजिन करिए that there is a grocer right next door, and your mother orders milk. Now the grocery shop owner, instead of coming to your house directly, has people working for him. So he sends one of the chotus to your house. Now the chotu on the way drops the milk packet and the entire milk is absorbed by the road. ठीक है, धरती माँ पी लेती है आपके milk को. Now my question is that chotu liable? Will that chotu compensate you for the loss of item? Isn't that the uncle's responsibility to give you the fresh packet of milk? Isn't it? And this liability is called vicarious liability. So if there is a person who is working on behalf of another person, right? अगर एक आदमी है जो किसी और के behalf पर काम कर रहा है, and that person commits or violates somebody's right while doing something for somebody else, right? So that liability, that violation is not just the person's responsibility, but also the person's responsibility whose work was being done. अगर मैं किसी के लिए कोई काम कर रही हूँ और उस काम को करते वक्त मुझसे किसी का राइट वायलेट हो जाता है, तो मेरी तो है ही जिम्मेदारी, लेकिन जिसका काम मैं कर रही थी उसकी भी जिम्मेदारी होगी, और इसको हम वाइकेरियस रिस्पॉन्सिबिलिटी कहते हैं. अब क्वेश्चन जो इस जजमेंट में है वो ये है कि इफ अ चेक इज डिसऑनर्ड एंड द चेक which is dishonored belongs to a particular firm, or let's say the person whose check is dishonored has a guarantor. यहाँ पे let's say कि B ने चेक दिया C को और B का जो चेक था वो बाउंस हो गया. अब B पे 138 और 141 NI एक्ट की जिम्मेदारी आ जाएगी, लाइबिलिटी लग जाएगी. Now the question that was discussed in this case was, will A also be liable under section 138 and 141 of the NI Act? Will A also bear the same brunt because he was the guarantor? Not just the master. Master can recover. Yes, owner is liable. Owner is liable. मतलब ऐसा नहीं है owner pay करता है because he is at a better financial stance. So obviously, if he is at a better financial stance, he would pay, but it doesn't mean that the servant is not liable at all. The law does not create a liability, but there is a personal liability. So owner might, deduct some amount from his income or something. So yeah, liability is not imposed on him by law because he is unable to bear the burden of a civil liability, of compensation, etc. Got it? Okay. Yeah. Now, did you understand what is asked in this case? What was discussed in this case? So, if B deposits a check or B gives a check to C, the money lender, and his check bounces, will A also be liable in this situation? Or let's say B is a partner. Oh, B is a firm. Okay, and A is a partner in that firm. Now, this firm gives a check to a person and that check bounces. So, is every partner of the firm liable for this bounce? The question to this answer, the answer to this question is no. And that is what the case law said. Now, why? Why? Because vicarious liability is a civil liability. Contract of guarantee is also a civil contract. Anything that happens within these two domains is under the ambit or category of civil. The penalty that these two sections create, section 138 and 141, together cumulatively constitute a criminal liability. सिविल लाइबिलिटी के बर्डन पे आप किसी और को इंक्लूड कर सकते हो, लेकिन क्रिमिनल लाइबिलिटी के बर्डन में आप एक आदमी को तब तक इंक्लूड नहीं करोगे जब तक उसकी गलती नहीं है. और यही क्राइम का जूरिस्प्रूडेंस है. यू नीड टू हैव actus reus, mens rea, both, in order to be declared a criminal, in order to be served a penalty in form of imprisonment. You need to have done something. If you haven't done something, if there's no actus reus, if there's no mens rea, law cannot punish you, and that is the basic jurisprudence of criminal law. Now, since these two sections together form a criminal liability, the scope of this liability will not extend to the civil domain, which means that A will not be liable for the check bounce. Do you understand? Got it? Everyone? Hindi, English, both. You understood, right? I told you. Yeah, I have mentioned both the sections, 138 and 141. That is not important. Everybody who doesn't, and Lakshmi, you understood, right? You don't understand Hindi, right? Okay, good, great to know. Moving on. So the vicarious liability in the criminal law in terms of 141 cannot be fastened because of civil liability. Vicarious liability can be penned when the person is in overall control of the day-to-day business, and only then he can be pulled towards the NI Act ambit, but not otherwise. So the guarantee will apply. The check bounce is a different act. Check bounce is a different act. Guarantee, it is a contract. It is a contract of guarantee. There's a certain duration, there's a certain duration, and within this duration, if the person is not able to pay, I'll pay. So there's nothing about check bounce. That is what I'm trying to explain. The act of check bounce is a criminal act and it won't extend to civil liability. So if I am somebody's guarantor and his check bounces, I won't be burdened with the penalty of section 141. Okay, if he is not able to pay at all, like towards the end of the contract, then the liability might be incurred on me, but not otherwise. Okay, everyone, good. Moving on. Now, tenant continuing in possession after the expiry of lease is liable to pay mean profits. Now, this is something that I've learned to say after a long time. I used to pronounce it as mesne, but turns out it is not mesne, it is mean. Things that I've done. What is the minimum marks? I think 70 to 75. It might be less, depending on what the merit is. Okay, so it actually depends on the merit, but if you are somewhere between 70 to 75 and you belong to SC category, NLS should be possible. Why are you laughing at tenant? What's so funny about tenant? Now everybody is laughing. What happened? I want to know. The word is spelled right. Are you laughing because... Okay, let's continue. So this is a far-fetched thing, but it does contain topics that I would want you to understand, because exams are unpredictable, and these are some laws that nobody teaches and you don't study because they're not as relevant. If there is a passage, it's very unlikely that a passage would come from property laws, transfer of property act. But if it does come, 70 marks for a student belonging to a category, 70 to 75, it might be more also, it might be 75 to 80 also, depending on the merit. But to play on the safest side, like if the paper is difficult and all, the merit will go low anyway. So this is the overall structure. Like 70 to 80 is the window that I think is possible, that makes possible for an SC student to get into NLU. Yeah. No, that's okay. I mean, I don't really understand, but you can laugh. Not a problem. Everybody is allowed to laugh. Right. So now in this case, the Supreme Court held that a tenant at sufferance cannot be general. For general, you need to score above 100. 95 to 100 is the minimum. If you get 100 plus, there's a high possibility that you might be in. Actually, no. For general category, I would say that the cutoff would be for NLS. It's very hard to say. Actually, I might have gone a little lower. For SC categories also, the cutoff might be above 80. 80 to 85 भी हो सकता है, क्योंकि जनरल कैटेगरी के लिए तो देखो एनएलएस टॉप कॉलेज है, तो टॉप रैंक एनएलएस पे मिलती है. तो आई थिंक जनरल कैटेगरी में अगर आप 100 प्लस हैं तो आप एनएलएस मिल सकता है 100 प्लस पे. ठीक है, 100 प्लस पे एनएलएस मिल सकता है. बाकी मेरिट पे देखो बहुत डिपेंड करता है, मेरिट कब कितना जारी है, कितना डिफिकल्ट है पेपर. तो ये मतलब एकदम कहना कि कितने नंबर पे एडमिशन हो जाएगा थोड़ा डिफिकल्ट है. बट फॉर जनरल कैटेगरी स्टूडेंट्स टू बी सेफ एंड टू for any good, if you are targeting a tier 1 national university, you need to secure 100 plus to be on the safe side, completely safe. So if you are getting above 100, even if it is 101, you are definitely getting the best national university. So we have covered details. See, Priyanka, we are sending you the links. The team is sending you the link. So every detail regarding the cutoff and SCs and general is actually covered in this session. So you can refer to that. I might be wrong also. I get confused within these merits until and unless I see the question paper. Okay? Yeah. Now, there are two concepts basically. How do I delete this thing now? I don't know how to delete it. Oh man. There's no eraser. Okay, fine. We have less area to work with. Now there are two concepts. Let's say that this much is enough. Okay. Let's say that you have a land. Okay. And there's a boundary outside the land. And you don't live on it. Like it's just a plot. It's just a plot that you hope to get constructed someday when you have money. Now, there's one person who sees an empty plot and he seizes the opportunity, enters in the plot and starts building his house on that empty piece of land. Now, what would this act be? अगर एक खाली जमीन पर जो तुम्हारी है एक अनजान आदमी आके अपना घर बनाने लगता है, उस एक्ट को हम क्या कहेंगे? ये ए जो हरकत की है इस ए ने, इस हरकत को क्या कहा जाएगा? what would we call this? Anybody? Jaldi se. You should be able to answer this question. Very good, Harshita. This is what we call trespass. Right? Trespass is punishable in torts. Punishable as in you have to pay or give compensation. Even if you haven't caused any loss to the owner of the property or to the possessor of the property, it is still violation of right to property for which you have to face consequences, right? Now let's say we have a tenant. Who was living in a particular house. Now there was a direction of eviction. He was asked to evict the land, but he did not evict the land. Now the landlord could have filed a suit against him, but the landlord continued with that adverse possession. What is this? Is this trespass? Will we call him trespasser? अब यहाँ पे टेनेंट जो है उसको एविक्शन नोटिस मिल गया है, ठीक है, और लैंडलॉर्ड ने कहा इसे तुम खाली कर दो, लेकिन टेनेंट ने खाली नहीं किया. अब वो अभी भी कंटिन्यू कर रहा है उस पे रहना और लैंडलॉर्ड भी उससे कुछ कह नहीं रहा. तो क्या हम अभी भी इसे ट्रेसपासर कहेंगे? विल वी कॉल हिम ट्रेसपासर? इफ यू अंडरस्टैंड व्हाट आई मीन, हरी अप. We won't call him trespasser because there is an element of landlord's permission. Even no matter how bleak it is, but there is still an element of permission, and that is why we won't call him a trespasser, but we would call him tenant at sufferance. He is living at the suffrage of the landlord. Okay, tenant at sufferance. His continued possession is causing some inconvenience to the landlord. That is, I think, not the, it is actually the right derivation. So that is why this person, this tenant, will not be called a trespasser, but he will be called tenant at sufferance. Now, all the leases, okay, lease is basically renting, taking something on rent. Okay, that is what we call lease also. Every lease comes to an end, and this ending of lease is called determination of lease. Okay, when the lease is end, when the lease ends, we call it lease is determined according to property terms. Now, lease can come to an end by various factors. There might be a contract for a particular duration, and when the duration comes to an end or the duration expires, the lease also expires, right? Or if the purpose for which the land was leased is, over, so the lease will also expire by the because of that factor. So lease can end because of various reasons. अब क्या अब क्या होता है कि क्वेश्चन आता है कि लेट्स से द लीज हैज कम टू एन एंड बिकॉज ऑफ एनीथिंग. लेट्स से टाइम, there was a certain duration for which the land was leased. The duration has come to an end, the lease is also expired, but the tenant is continuing on the land. Now the question is, let's say the tenant is continuing on the land because of which the landlord is suffering. Okay, he is suffering, he is losing money because of it. Is the tenant under a liability to pay for the loss that the landlord is suffering? Is he? Let's say कि मैंने एक ऑर्चर्ड लिया लीज पे, ठीक है. अब उस ऑर्चर्ड में फलों के पेड़ थे और मैंने उन पेड़ों की वजह से ही उस ऑर्चर्ड को लीज पे लिया था. अब मेरी जो लीज थी वो खत्म हो गई, लेकिन मैंने लैंड को वो नहीं खाली नहीं किया. आई डिड नॉट वेकेट द प्रॉपर्टी. अब मैं अभी भी उन ट्रीज को, उन फ्रूट्स को यूज कर रही हूँ, जिसकी वजह से वो लैंडलॉर्ड जो है वो उन्हें यूज नहीं कर पा रहा. अगर मैं लैंड को वेकेट कर देती तो उस प्रॉपर्टी से जो भी फ्रूट निकलता, उस प्रॉपर्टी से जो भी फायदा होता, वो फायदा लैंडलॉर्ड को मिल जाता, लेकिन मेरी वजह से वो फायदा लैंडलॉर्ड को नहीं मिल रहा है. तो अब लॉ कहता है कि भाई तुम्हारे लैंड पे कंटिन्यूएशन की वजह से लैंडलॉर्ड जिस फायदे को रीप नहीं कर पा रहा है, उस फायदे को तुम उसे पे करोगे, और यही फायदा, यही प्रॉफिट मीन प्रॉफिट कहलाता है. Let me explain this in English. Let's say that I am continuing on a particular piece of land, and that land is giving me some benefit. Let's say that it has a lot of fruit trees on it, and I'm reaping all those fruits, selling them in the market. Now if I continue on the land, the landlord won't be able to reap the fruit of the land, right? So if the moment or the duration till which I continued, landlord will continue losing some benefit or profit. Now if I would have vacated the land, the landlord would easily have reaped the profits and he was entitled to certain profits, but he is not getting those profits because I am on the land, because I am possessing the land. So that profits that he is not getting because of my possession is called mean profits, and according to civil procedure code, landlord is entitled to the mean profit. So the duration to which I am possessing the land because of which the landlord is losing some money. I am under a liability to pay that much money to the landlord, and that money is paid in form of mean profits. The profits that the landlord should have gotten had I vacated the land at the right time. अगर मैंने लैंड को टाइम से खाली कर दिया होता तो जो भी बेनिफिट लैंडलॉर्ड को मिलता वो मीन प्रॉफिट होगा. तो अब वो नहीं ले पा रहा है क्योंकि मैं हूं लैंड पे, तो मेरी जिम्मेदारी है कि मैं उसे वो सारा का सारा प्रॉफिट दूं. Everybody understood? English and Hindi both? Everybody, did you understand? Is there any doubt whatsoever about what mean profits are? Yes? No? Understood? Should I move on? Good. If landlord oppose it, then maybe. Acha, okay, you were answering. So a tenant continuing in possession after the expiry of the lease may be treated as tenant at sufferance. Okay, they're not called trespassers, they are called tenant at sufferance because they did leased the property. They did lease the property. Okay, so this is a little bit higher status than that of a mere trespasser. This is not really an encroachment because the original entry was lawful. So his exit or his continuation will not be considered completely unlawful. So the landlord is entitled to the damages for the use and occupation at any rate which the landlord could have let out the premises on being vacated by the tenant. Again, let's understand it through an example. Okay, you have understood. Let's move on. Now, in camera trial, in all sexual harassment cases apart from rape cases, Supreme Court. So the case name is XYZ versus State of Madhya Pradesh. Now, as per Section 327, generally, the CRPC or the Code of Criminal Procedure mandates that all the criminal proceedings have to be conducted in an open court, because criminal proceedings basically whatever happens in a crime impacts the entire society. Everybody knows it, right? So a crime is not just an individual act, it contains or it takes the entire society with itself. Everybody gets disturbed because of it. Now, since the justice is given, it should be given to everyone. हर किसी को मिलनी चाहिए. So whenever a judgment is being delivered or whenever a proceeding is conducted in for a criminal case, it is conducted in an open court so that society can rest, so that the society knows कि भाई उस आदमी के साथ क्या हो रहा है. For example, let's say there is a very old dacoit A, and he is very famous, and he's not famous, he's infamous of many murders and robberies and dacoities. Now, if he is being tried by a certain courts, let's say ABC, everybody would want to know the verdict, or everybody would want to know what is happening inside the court, because it is because of him their families and their relatives and whoever he tormented suffered, right? Yeah. अब ए जो है बहुत ही बदनाम डाकू है, और अब अगर इसके साथ कोई भी प्रोसीडिंग हो रही है तो सोसाइटी जानना चाहेगी कि भाई कोर्ट क्या कर रहा है इसके साथ, हमें जस्टिस मिलेगा या नहीं मिलेगा, क्योंकि क्राइम का जस्टिस सिर्फ एक विक्टिम को नहीं मिलता, पूरी सोसाइटी को मिलता है, राइट? तो इसीलिए क्रिमिनल प्रोसीडिंग्स को ओपन कोर्ट में रखा जाता है, सो दैट एवरीबडी नोज व्हाट इज हैपनिंग इनसाइड. नाउ द क्वेश्चन इज, व्हाट इफ the case relates to an offense which is personal, sexual offenses, rapes. Now, Section 327 of CRPC says that if it is, yes, right to information, sort of. So, if it is a rape case, the proceedings will not be conducted in an open court, because rape traumatizes not the society but the victim more. The status, the life of the victim gets prejudiced. Like, people become prejudiced. Her life further will always be an object of gossip if it goes out in the open. So the identity of the victim, the name of the victim, everything relating to the victim, her family, her parents, everything is kept a secret. Now that is why even the name is not revealed when it comes to cases like these, and that is why XYZ. Okay, got it. So section 27 says that if it is a rape case, in-camera trials are mandatory. But section 327 says that in-camera trials are mandatory only in rape cases. Now the question that was discussed in this case was, it's not just rape which is personal to the victim. There are similar offenses which are not as extreme as rape but bear the same connotation, and these offenses are sexual offenses. So sexual harassment, sexual violence, if it is not exactly rape, should also be conducted within camera in a closed setting, in a closed court. And that is what was held, or sorry, that is what was plead in XYZ state versus state of Madhya Pradesh. Now, Madhya Pradesh sort of rejected the plea, and the case went to the Supreme Court. And in this case, Supreme Court held that apart from rape cases, sexual harassment cases also come within the ambit of in-camera trial. So, if it is a sexual harassment case, a victim is entitled to a closed trial. She is entitled to a proceeding which is not made public. And even if there is no particular or express provision to that regard, she deserves that privacy under Article 21. Okay. That kind of privacy is mandated or given to her as her fundamental freedom under Article 21. Okay. Got it, everyone? Did you understand? It's very easy but very interesting also. Right, everyone? Should I move on? Yes. Now, ensuring that cross-examination, it's not just in camera means closed court. Yes, the media is not allowed. Anybody who is not directly related to the case is not allowed in the court. Otherwise, civil court is a public place. Everybody can enter. You can just enter the court, watch the proceedings, very easy. But rape cases, the doors are closed from inside. Nobody can enter unless they have an express permission, right? So in rape cases, generally the closed proceedings are preferred because the victim is scared and insecure as it is. So the cross examination might make her uncomfortable. There would be personal questions relating to what happened to her, and these questions are not just in rape cases. The questions would be same in sexual harassment cases also, which might make her uncomfortable. So the benefit of closed camera proceedings should not just be limited to the rape cases, it should extend to sexual offenses or sexual harassment cases also. इन केसेस में सेक्सुअल हिस्ट्री अक्सर सामने आ जाती है, क्योंकि डिफेंस हमेशा आर्ग्यू करता है कि भाई कंसेंट इन्वॉल्व था. अब कंसेंट को प्रूव करने के लिए बहुत सी डर्ट निकल कर आती है जो कि एक लेडी को अनकंफर्टेबल कर सकती है, और इसलिए क्लोज्ड कैमरा प्रोसीडिंग्स प्रेफर की जाती हैं, राइट. अब इस केस के बाद थैंकफुली ये जो बेनिफिट है क्लोज्ड कैमरा प्रोसीडिंग्स का, ये एक्सटेंड कर दिया गया है कि भाई सिर्फ रेप में ये पर्सनल और ये प्राइवेट मैटर नहीं होता है. सेक्सुअल ऑफेंसेस चाहे वो कितना ही मीगर क्यों ना हो, कितना ही छोटा क्यों ना हो, उसमें भी क्लोज कैमरा प्रोसीडिंग्स जरूरी हैं. क्योंकि अगर एक्सप्रेस प्रोविजन नहीं है तो भाई आर्टिकल 21 तो है, वो तो प्राइवेसी को गारंटी कर ही रहा है, फंडामेंटली कर रहा है, तो यहाँ पे क्लोज प्रोसीडिंग्स ही होंगी. Got it? अब इससे रिलेटेड बहुत सारी चीजें हैं. There are some things that you should be familiar with. Section 154. Now you might not be asked this question in this exam, but when you take PCSJ, whoever wants to become a judge, this is the question that will be asked in one of the exams, but it will be asked 100%. Section 144 CRPC. What does it entail? Section 154 CRPC provides for the process of recording FIR. Now section 154 does not define FIR, mind you. FIR की डेफिनेशन नहीं है कोड ऑफ क्रिमिनल प्रोसीजर में, लेकिन FIR कैसे रिकॉर्ड होगी, उसका क्या प्रोसेस होगा, उसकी क्या मैंडेट्स हैं, उसकी क्या प्री रिक्विजिट्स हैं, वो सारे सेक्शन 154 में दे रखे हैं. ठीक है. सो FIR होता क्या है? फर्स्ट इंफॉर्मेशन रिपोर्ट इज द फर्स्ट इंफॉर्मेशन और द रिपोर्ट ऑफ द क्राइम committed, and it is the first information or the first report of the committed crime. That is what we call FIR. When the police gets to know that an offense has been committed. Now, there are certain mandates or prerequisites when it comes to FIR. For example, whenever they receive a complaint, it is their duty to record it under section 154. They cannot deny, or they cannot say no to the record of FIR. एक पुलिस ऑफिसर FIR रिकॉर्ड करने से मना नहीं कर सकता. ये उसकी ड्यूटी है कि वो FIR या कोई भी कंप्लेंट जो आई है उसको FIR के फॉर्म में रिकॉर्ड करे if he thinks that a cognizable crime has been committed. Cognizable crime is a crime for which an arrest can be made without a warrant. Right? That is a cognizable offense. If the offense is of lesser intensity, which means it is a non-cognizable offense, FIR is not needed. Then it is a NCR, non-cognizable offense report, which is reduced or which is recorded under section, that's your homework. Okay. In which section is NCR recorded, or information relating to non-cognizable offenses? That's your homework. So if the police officer thinks that if a police officer thinks that a crime that is committed is non-cognizable, he may record it under NCR or non-cognizable offense report. But if it is a significant cognizable offense, which mostly are, then FIR will be recorded. Yes. Now, after conducting the investigation, now the process is that, after the investigation is conducted, there are two choices which a police officer has to make. So, he'll decide an offense is committed, or he may decide that an offense is not committed. So, if he decides that an offense is committed, he will file the charge sheet. The charge sheet is submitted to the court. The court takes the cognizance of the charge sheet and the trial begins. फिर होती है ये अरेस्ट और ये एविडेंस, तारीख पे तारीख, और ये सब उसके बाद होता है, पहले नहीं होता. अगर पुलिस को लगता है कि भाई क्राइम नहीं हुआ है, क्राइम के लिए एविडेंसेस ही नहीं है, कुछ ऐसा एविडेंस ही नहीं है, प्रूफ ही नहीं है जिससे कंक्लूसिवली कहा जा सके कि क्राइम हो गया, तो चार्जशीट फाइल नहीं होती है. क्या होता है? क्लोजर रिपोर्ट फाइल होती है और केस को वहीं पे क्लोज कर दिया जाता है, वो कोर्ट तक पहुंचता ही नहीं है. अगर ये क्लोजर रिपोर्ट भी कोर्ट में फाइल की जाती है, ठीक है, चार्जशीट और क्लोजर रिपोर्ट दोनों ही कोर्ट में फाइल की जाती है. अगर क्लोजर रिपोर्ट फाइल करने के बाद भी मैजिस्ट्रेट को लगता है कि नहीं यार थोड़ी सी और इन्वेस्टिगेशन होनी चाहिए थी, मुझे लगता है इन्वेस्टिगेशन पे ठीक ठाक इन्वेस्टिगेशन पे मिल जाएंगे एविडेंसेस और निकल आएगा कि ऑफेंस हुआ था, तो फिर इन्वेस्टिगेशन को रीओपन किया जाएगा. और नहीं भी किया जाएगा तो भी क्लोजर रिपोर्ट के बाद भी मैजिस्ट्रेट चाहे तो केस के साथ कंटिन्यू कर सकता है. एक जुडिशियल मैजिस्ट्रेट के पास बहुत सारी पावर होती है. आरुषि तलवार के केस में सीबीआई ने क्लोजर रिपोर्ट फाइल करी थी, ठीक है, एविडेंसेस नहीं थे किसी को भी इंक्रिमिनेट करने के, जिसपे जो प्राइम सस्पेक्ट था वो ही मर गया था, और एक फादर पर डॉटर के मर्डर का जो चार्ज था वो फिट नहीं बैठ रहा था कहीं से कहीं तक. तो आरुषि तलवार के केस में क्लोजर रिपोर्ट फाइल की गई, लेकिन इस क्लोजर रिपोर्ट से जो सीजीएम थी, चीफ जुडिशियल मैजिस्ट्रेट, वो सेटिस्फाइड नहीं हुई और क्लोजर रिपोर्ट फाइल होने के बाद भी उसने केस को कंटिन्यू रखा और राजेश तलवार को जेल हो गई. ठीक है, एवरीबडी आंसर्ड. लक्ष्मी, I used a lot of Hindi. Do you want me to explain everything in English? I should, right? Lakshmi, do you want me to explain everything in English or should I just continue? Is she here? Did she leave? I thought she was here. Let me know. I'll explain everything again. Okay? Yes. Moving on. You understood? Great. Now, the relevant provision in this case is section 327, Code of Criminal Procedure 1973, which declares or mandates the court to be an open court. No, I'm not doing any preparation. How to manage CLAT with 12th. Random questions. I have A2, okay, what's your name? I have dealt with these questions in my other sessions which were dedicated to thus just these queries. ठीक है, मैंने इस तरह के सेशंस लिए हैं जहाँ पे मैं आपको स्ट्रैटेजीज देती हूँ कि भाई 12th के साथ कैसे मैनेज करें, कट ऑफ कितनी जाती है एससीज के लिए, जनरल्स के लिए. तो इस तरह के अलग अलग सेशंस होते हैं. तुम थोड़ा सा ढूंढोगे तो तुम्हें पूरा का पूरा सेशन ही मिल जाएगा और वो तुम्हें बेटर एक्सप्लेन कर पाएगा. ठीक है, तो ये सेशन है, तुम एक बार देखो, मैंने ही लिया है, उससे तुम्हें ज्यादा हेल्प मिलेगी. यहाँ पे तो सेशन के बीच में मैं तुम्हें थोड़ा सा गाइड कर पाऊंगी, लेकिन अभी वो तुम उस सेशन को जो सिर्फ इसके लिए डेडिकेटेड है वो तुम्हें ज्यादा हेल्प कर पाएगा. व्हाटएवर योर नेम इज बडी. A2 की मस्ती. Yes. So section 327 of CRPC 1973, I already told you what the significance of the section is. Now message should go that dowry death shall be dealt with an iron hand. Now, you know, dowry menace was an uncontrolled menace. Back somewhere around in 60s, 17, in fact, till late 80s, till early 90s, dowry was such a menace that it was getting impossible to control it. Ayush, your name is Ayush. Okay, so Ayush, like I told you, I have taken dedicated sessions on your questions, buddy. So those sessions might help you more than, you know, me giving only a few minutes to your query, because it is actually a relevant problem. ये दिक्कत होती है बच्चों को, तो मैंने एक सेशन लिया है इस पे, आप उसे देखो, वो आपको हेल्प करेगा. ओके, you can just google that, how to manage 12th with boards. A lot of sessions will come. Now, so dowry was a menace that was uncontrolled, and there were so many women that died at the hands of a family's greed. मतलब जो ग्रीड थी वो संभालने में नहीं आ रही थी, और इस ग्रीड की वजह से कितनी लड़कियों ने, कितनी बेटियों ने, they had to lose their life, they lost their lives because somebody was just greedy beyond imagination. And they were not just greedy, they were vicious, they were ruthless. They decided that the lady should die, and the lady should not just die, they decided to kill her, burnt her alive. What came over them, and nobody could understand why that was happening. Like, why were the, you know, daughter-in-laws burnt alive just because their families could not gratify the greed of their in-laws? So what was the need? What was the need of killing those women? Why could you just leave them? Why could you just ask them to leave the house and go back to their parent? At least lives would have saved. But people were not listening. Nobody was, the menace was not getting controlled. The greed was not getting controlled. And that is why, you know, the process of dealing these cases with extreme partiality came into picture. Now the legislations and the interpretations of these legislations started towards women, like, you know, yeah, who gets the money. So the interpretation of these sections, the legislation that were coming, they came solely for the purpose of saving women, and that they were extremely women oriented. They did not consider even for a single second that a lady might be manipulating or she might be vengeful towards her in-laws, because that used to be one cases out of 100 people were suffering. One case maybe was because of this malified intention. Now, because of that one case, people or other, you know, actual victims could not suffer, and that is why the courts were, I won't deny it, the courts were actually biased. Okay, although in, you know, further investigations and if further in the trial, अगर एक mal practice होती भी या malified वो जो सॉरी एक malicious prosecution होता भी था, तो वो सामने आ जाता था, क्योंकि भाई malicious prosecution malicious ही है, उसको बेस देने के लिए एविडेंस तो है नहीं. अगर तुम कह रहे हो कि लोगों ने मुझ पर अत्याचार किया है, मुझे क्रूअल थे, ये दहेज मांगते थे, ये तो तुम्हें प्रूव करना पड़ेगा. तुम्हें प्रूव करना पड़ेगा कि हाँ, तुमने इनकी डिमांड्स को बार बार सेटिस्फाई किया है और फिर भी इनकी डिमांड खत्म नहीं हो रही, तब तुम्हारा केस बनता है, राइट? या फिर डेथ ही हो गई. अब अगर डिमांड है ही नहीं तो फिर एविडेंस भी नहीं होगा। और इसलिए ये जो केसेस होते हैं मलिशियस प्रोसिक्यूशन के, ये एक सर्टेन एक्सटेंट पे जाके डिसमिस ही हो जाते हैं, एक्चुअल विक्टिम सामने आ ही जाता है, राइट। अब इसी को ध्यान में रखते हुए कोर्ट्स जो थे वो लेडीज को, फीमेल्स को लेकर, स्पेशली विक्टिम्स ऑफ डोमेस्टिक वायलेंस, विक्टिम्स ऑफ डाउरी मेनेस, they were specially sympathetic towards these victims, and that is why the legislations were drafted because inclined towards women. So that is why, you know, people are so always saying that whatever a woman says become, what should we say, an absolute evidence or an absolute voice. Whatever she says is true. No, nobody can go beyond that. That is somewhat true. Although, because of many false cases getting registered, the courts have now become cautious, but the menace is still going on. Despite the fact that we have strict legislations to deal with it, the menace is still continuing. For what reason? Nobody can say. Humans have always been greedy. They are never satisfied. And maybe the dowry, that is why, you know, the greed is not getting checked. And majorly, I think the problem is that, you know, the girl's family is ready to give. So if you give something to somebody for free, they will never say no. Who would say, if I'm getting something for free, why would I say no? I would definitely accept it. And if it keeps on coming, my greed will increase. So it's, you know, it's a two-way lane. The both parties are involved. Don't give them anything. Be strict from the very beginning, and maybe that way you can control this menace. Anyhow, yeah. So in this case, Ajola Devi and another versus state of Jharkhand. Now you would be wondering कि dowry death के जो cases है वो कम आते होंगे. There might be less cases registered for dowry death, but the problem is they're not. Women are still dying because of dowry, and this menace is extreme still in downtrodden areas or poor states such as Jharkhand, or, you know, rural background, or the states which are majorly rural. The dowry menace is still continuing. That is the problem. So in Ajola Devi and another versus state of Jharkhand, there's yet another woman who died at the hands of her in-laws because she could not meet with their dowry demands. Okay, and this time Supreme Court became extremely strict. Now, to deliver a certain message, they increased the punishment to 10 years. The punishment for dowry death is 7 years, and the maximum punishment is life imprisonment. So the person, so the people involved, including the mother-in-law, whose name is Ajola Devi, right, has been given 10 years. Everybody in the family, including the husband, the father-in-law, if he was there, and the mother-in-law, is given 10 years of life, 10 years of imprisonment. Now, 10 years out of a person's life spent inside or behind bars is a long time. Trust me, it's a very long time. Got it? So, what exactly is dowry death? Everybody understands what dowry death is. There are certain prerequisites. It is important you should know because it might be asked in your exam. So there are certain essentials, and even if one essential misses, it is not dowry death. It might be some other offense, लेकिन वो dowry death नहीं होगा. Dowry death के कुछ elements हैं, और उसको कंस्ट्रू करने के लिए कि भाई डेथ डाउरी डेथ है या 304 भी स्ट्राइक हो रहा है, ये देखना पड़ेगा कि भाई सारे essentials fulfill हो रहे हैं. All the essentials have to fulfill. Now, what are the essentials? The first is there has to be a lawful marriage. Okay, the marriage was lawful. There has to be a lawful marriage. The second is there was a death. Obviously, we are talking about dowry death. There was a death. This death has to be of a certain category, meaning thereby the death was unnatural. So naturally, if a person dies, it's a call of God. Lord Almighty wants you back at his home. But if a person dies under mysterious circumstances or unexpectedly, we call it unnatural, right? So if a person dies unnaturally or under mysterious circumstances within 7 years of marriage. Okay, the duration of marriage did not cross 7 years, and there were evidences that right before the death the woman was subjected to harassment relating to dowry right before her death. Now, right before her death does not mean few hours before her death. It means before her death in general. Okay. The meaning of right before death has been interpreted by Supreme Court for for obvious reasons, so that nobody can play with this loophole. So right before death does not mean that a few minutes before her death she was asked for dowry and then she was killed. No, right before her death means any time before she died she was subjected to harassment related to dowry. Now if all these elements are fulfilled, the court shall presume that the lady was killed at the hands of her in-laws, and the death will be called dowry death, and the burden is on the defense to prove that the death was natural and it was not a dowry death. Generally, the burden of proof lies on the prosecution. The person who makes accusations has to prove those accusations. This is the usual course in a criminal process. एक आदमी जो इल्जाम लगाता है उसे उन इल्जामों को साबित भी करना पड़ता है, लेकिन डाउरी डेथ में ये रूल नहीं चलता. यहाँ पे जो इल्जाम लगाता है वो बस इन चीजों को प्रूव कर देता है कि लॉफुल मैरिज थी, डेथ हो गई, अननेचुरली हुई है, शादी के 7 इयर्स के बीच में हुई है, और शादी से डेथ से पहले लेडी को डाउरी डिमांड के लिए हैरास किया गया था. जैसे ही ये 5-6 एलिमेंट्स प्रूव हो जाते हैं, कोर्ट मान लेता है कि लेडी को मार दिया है या फिर जो मरी है वो डाउरी की वजह से मरी है और उसकी डेथ के पीछे उसके इन लॉज का हाथ था. अब यहाँ पे बर्डन ऑफ प्रूफ प्रोसिक्यूशन के पास नहीं है, कुछ भी प्रूव नहीं करना उन्हें. इनफैक्ट डिफेंडेंट को प्रूव करना पड़ेगा, साहब हमने नहीं मारा, नेचुरली अपने आप मर गई थी. ठीक है, बिल्कुल उल्टा हो जाता है. तो द सेक्शन इज एक्सट्रीमली स्ट्रिक्ट. इट्स इजियर टू प्रूव the allegations, it is difficult to defend or to prove the defense. समझ रहे हो? ठीक है ना? Everybody. So the person or the people involved were given 10 years of rigorous imprisonment. Now this sentence was challenged by the High Court, in the High Court, and then again in the Supreme Court. The sentence was upheld by the High Court, and later on it was upheld by the Supreme Court also. And in fact they didn't just go with 10 years imprisonment, they changed it to 10 years of rigorous imprisonment, saying that if you can increase the penalty, do it. Give them the maximum penalty possible for people who are still demanding dowry. Got it? Yes. So these are the relevant provisions, section 304B of IPC, right? We have already understood. So where death of the woman is caused by any burns or bodily injuries or occurs otherwise than under normal circumstances within 7 years of her marriage, and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of her husband in connection with or any demand for dowry, such death shall be called dowry death, and such husband or relative shall be deemed to have caused her death. कोर्ट ये मान लेगा कि इन लॉज ने डेथ कॉज करी है. ठीक है, गॉट इट? Right, so that's it for today, guys. I hope you understood the concepts involved. Like I told you, it's not the judgments that matter, but the philosophy and the law behind them, and that is what give you a certain knowledge कि भाई अब तुमने पढ़ लिया कि सुप्रीम कोर्ट का ये केस था, अब तुम्हें साइटेशन नहीं याद रखनी है, तुम्हें टाइम नहीं याद रखना है, लेकिन तुमने कितने सारे, यू अंडरस्टूड डाउरी डेथ, यू अंडरस्टूड वाइकेरियस लायबिलिटी, यू अंडरस्टूड एनआई एक्ट सेक्शन 141, you understood contract of guarantee and a lot of other concepts relating to it. So this is a very good way to prepare, along with getting in touch or keeping keeping yourself updated with the current happenings. So everybody take care. Thank you so much. I shall see you again tomorrow, same time. Till then, take care. Bye bye. Good night.